So now we have a very distinguished panel with us. All the people who are here are expert in infrastructure. In fact, they are Supreme Court lawyers, advocate on record, and also senior advocate like Priyaji and also Alok Agrawalji and others. Kadambari is there. Thank you very much for joining. And now to begin the program, what I'll do is I'll request our chair of the committee, Infrastructure Development Committee, Mr. Sudhir Hoshing, to give industry perspective because Mr. Hoshing, you are also, literally facing the arbitration on the ground level. So kindly tell your experiences so that our experts can definitely give their view on this. Over to you, Mr. Hoshing.
Thank you, Ranjit, and I really welcome all the participants who have come, the speakers who have come here, and we're going to discuss this very important matter, which faces us, which we face day in and day out. Maybe my comment may not be liked by my advocate friends, but the thing is that I want a situation where we don't get into this. Why we should at all get into it after so many years of the same vendors and same contract, and same contract is there, same vendors, same issues, and we still get into this from last 15-20 years. Every time you'll find the issues are almost same, and we are just harping upon. I don't know why NHI get into this, especially I'm talking about here as a road builder and whose common client is National Highway Authority. And as we know, I think there will be many thousand crores of litigation issues going on with NHI today, and such a big thing, and they are not able to do anything. They are not able to improve themselves upon it. And the whole issue about it is, if you see, every project of mine would go into arbitration. Every project, irrespective whatever it is. I don't remember now. There was a time when we were not actually fighting ourselves out uh, against NHA, thinking that no, they are my Bob, let's not fight with them. But then that's not my view. I see we are equivalent to them, and we are their partners. We do most of the PPP projects, and we develop their projects. Why the hell I should worry about them? If they have given me some contract, either I should have abided or they should abide, and then all costing, everything is about profit making, or everything is about survival today. It's not only about profit making. So issues, I think all of you would have handled the issue remains around today, or issues are basically generated from land which have not been given on time. One, change of scope. Two, that means land, you are not given full land at the time, and even if they say 80% of land given, you end up finding that actual possession is not even 30%. Even though said, okay, we are giving you at this stage 80% of land has been taken, but really you are not able to enter even 30-40% in some cases. And issues start from there. Then project get delayed. Then you fight for every inch, every nail, every bite, because once you are delayed, NHA wants to put everything on your head, and they want to get scot free. They are in mode of denial most of the time. They know that they are making mistake, but they are always in mode of denial. They don't agree. And in fact, I think at each level, they think this will become my mistake, being taken it at personal level, say PD taking it at personal level, that I have not given land, and they have no power to actually say, if in my contract, if I have given a contract to somebody, they will come to us that I have not been given this money, give me escalation. So I will manage with him. I'll give him some money so that he becomes 0-0 situation. But it doesn't happen with the concession. It doesn't happen with the main contractors. And that is where so much of litigation starts. So land is the prime issue, and everything moves around that. And since land is not there, you can't move the utilities. The utilities become as number two. because they were not shifted on time, and because of that, no, you actually cannot enter the land and you cannot start the work, and work gets delayed. Once the work gets delayed, then there are issues of all which crop up, the money, the idling, and all those things. And now, as they become more and more tighter, banks become more and more tighter. We have no way but to go for arbitration, and then say, at least arbitration for that matter has improved over a period of time. Now I am able to get my results in 6 to 8 months. That is happening. So that is the improvement which has happened over the years. But this is what has happened. And then third is a very poor DPR which is made still. It is not changing. And because of which lot of change of scope comes, then you are fighting with them that actually this is not right, what you have given is wrong, so you have to make this, you have to give extra cost, because you are doing a PPP project, your entire cost, every inch of your cost is fixed. There's no way I can get more money. Only way money comes is you to put more equity, which will make project unviable at 100%. So the question becomes of survival. Once you are delayed, every day of delay means if your project is delayed, of 1,000 crore project is delayed by a year, you have lost 150 crores almost. So it's such a big money. That means every month you have lost at least 30 crores or 10 crores, and then every day maybe 3 to 4 crores. So that's the impact which we are talking about. And if it is a BOT toll, then your loss of toll is also added to it. And if you ham project, then your loss of annuity if it becomes, if NHI doesn't agree. Every issue starts from there. Then you go into dispute. Then you further go into arbitration. Then you, even at arbitration stage, if NHI is not agreeing, then you have to go to court and end the matter there. So that is how it is. Things have not changed. Things are still same. Uh, I would say only thing which has changed that the arbitration process has become faster than earlier. Now it finishes in 6 to 8 months time. I may be running at least 8 to 10 arbitration process right now, which is there in my hand. So that is how it is. So I leave the floor open, the discussion on this. I can chip in wherever required, but this is the premise on which we can talk.
Okay, Mr. Sudhir, thank you very much for your perspective. And at least you believe that now the process of arbitration has really improved and it is getting faster. That is also a very big advantage for the industry.
It is there.
Yeah. Now I would like to invite Mr. Ashish Vig, who is the mentor of our Infrastructure Development Committee, for his perspective on today's webinar. Vig sir.
Thank you, Doctor. Thank you very much. It's nice to see so many people here with us today uh, who will enlighten us on this very, very crucial and important topic, that is arbitration. I'll just start off with, with the basic formalities. Mr. Sudhir Hoshing, Chairman, Infrastructure Development Committee, Ms. Priya Hingorani ji, Senior Advocate, Supreme Court of India and Chairperson, Law and Justice Committee, Mr. Alok Krishan Agarwal, Chairman, Legal ADR Cell, PhD, Chamber of Commerce, Ms. Kadambari Singh Puri, Advocate and Standing Counsel, NHAI and Co-Chair, PhD, Skill and Entrepreneurship Committee, Dr. Ranjit Mehta, Deputy Secretary General, PhD, Chamber of Commerce, distinguished guests, colleagues from the industry, friends from media, ladies and gentlemen. With the permission of all, I'll take the liberty of speaking in English and Hindi. That's how I'm comfortable. मैं एक बड़ा ब्रीफ आपको बताऊंगा अपना व्यू पॉइंट. Since I'm not giving the industrial perspective, I'll just give you a very, very brief input of what I think about this subject. Let me, there are two two very basic things: expectation, and the other is trust. जब तवक्को ही उठ गई गालिब, क्यों किसी का गिला करे कोई. जब expectation ही गई, फिर things that we are going to have. We always see expectation, whether it's in the corporate world, in the world, in the social world, in the physical each other. That is, I feel, giving birth to a dispute. Having said that, I mean, अपने times में भी dispute हुई है. Expectations जो थी कौरव और पांडवों में वो पूरी नहीं हुई. We had Shri Krishna going there as an arbitrator. We come down, we see the panchayats that we have in the villages. What is that? That is again arbitration. Again, because of the expectations not true. The second point I mentioned is trust. See, it's very interesting when you, people who are fond of poetry and fond of shero shairi like I am, I just recited one, and the other one is on trust, bharosa. अगर भरोसा नहीं है तो आपके कॉन्ट्रैक्ट्स फेल करेंगे ही करेंगे, क्योंकि वन साइडेड कॉन्ट्रैक्ट्स बन जाते हैं, क्योंकि आपको दूसरे के ऊपर भरोसा नहीं है. You want to be extra safe, extra cautious, not really taking into consideration the other party, which, like very rightly Sudhir has mentioned, is an equal partner in the project. He used a very good word. He said, we are partners in the project. We are not party one, party two. Once we understand that, once we realize that, then I don't see much of a problem in execution of the project. Okay. Will not much time because I see experts here in our panel today, and the second session is going to be very exciting for all of us. But yes, I would also touch upon these 2-3 points which are important. One is the proper drafting of the agreements, the contracts. Proper drafting ना होने की वजह से हम लोग सब दिक्कत में पड़ जाते हैं. हम लोग अपनी अपनी इंटरप्रिटेशन करते हैं. The drafting has to be so clear, it has to be so transparent that both the partners fulfill their expectations, obligations with trust on each other. I feel apart from drafting, it's very important to also keep on maintaining the daily, as we used to say, the daily progress reports or the daily charts, so that you try and reduce any point or any chance of any discrepancy later on. जैसे सुधीर ने बताया, लैंड है नहीं और प्रोजेक्ट दे देते हैं एग्जीक्यूशन के लिए. अगर डे टू डे मॉनिटरिंग हो कि मुझे आज कितना मिला, मैंने आज क्या प्रोग्रेस किया, आज चांद निकला, सूरज निकला, बारिश हुई नहीं हुई, everything is logged. There should be a daily log. Then chances get eliminated. We have seen a lot of progress in arbitration laws, in the processes of arbitration. The courts have come in, and yes, there has been a change over what we used to see, but a lot more has to be done. You have a lot of international arbitration. All experts are seeing that. All people are looking at India as a very, very important base for international arbitration. I mean, one can go on and on and on, but I think I will not take much time, Dr. Mehta. I'll end up by saying one couplet again. I started off with expectations, and I would like to sum up with trust. And trust on trust That is what is important. Thank you so much.
Thank you, Mr. Vig. Though we could not listen to your couplet because of some, I think, internet connectivity, but I'm sure that was a really
मैं
good
दोहरा
one.
लेता हूँ, मैं दोहरा देता हूँ.
हाँ, बता दीजिए.
तेरे वादे पे जिए हम, तू ये जान झूठ जाना कि खुशी से मर न जाते अगर एतबार होता. तो
अरे वाह.
एतबार जरूरी है, ट्रस्ट
Very
जरूरी
good,
है.
very good, very good. So you end
ट्रस्ट
up definitely on a very good note that it is about the trust in arbitration also. Thank you very much, Mr. Vig. Now, ladies and gentlemen, I would like to invite Ms. Priya Hengurani, a luminary and senior advocate, Supreme Court of India and Chair, PhD Law and Justice Committee, for her remarks on today's webinar, for her address.
Thank you, Dr. Mehta. Very good afternoon to everyone. Thank you for inviting me and having me over again on another of your very important sessions. I think every time I attend your program, I learn a lot more and go back very, very satisfied. So it's kudos to you that you organize such interesting sessions and have some great speakers. I can see Kadamri, my old friend, Alok ji, Mr. Atul Nigam, who's joined in, who's partner of Nigam and Nigam. So it'll be good to hear all of them. And of course, Justice Deepak Mishra, who we've had the privilege of appearing before in the Supreme Court when he was a judge there, and seeing many of his landmark judgments when we keep reading them. My view to arbitration is very, very different, and I have said so on many platforms. Of course, I agree with Mr. Wick that the biggest problem when we have before the root problem is the drafting of the agreements which are made between any of the two parties who are involved in any kind of a deal or any project. And that is something where over traditionally we have seen that the institutions, the authorities always have an upper hand when they draft the agreements. The agreements are drafted for more for their benefit than for the benefit of the vendees. And it's always a difficult position for the vendees to try and negotiate their terms and conditions, because they always feel that we are getting the work and it's a big institution and we should, as Sudhirji said, it's a big any big institution has an upper hand. So I think that over the years has changed, not so much, but it has. And I think now the fact that the drafting of agreements has been, the lawyers have been involved in it for either the vendees or the institutions, has brought about some kind of a parity, if not equal relationship, but some kind of a parity in the drafting of the agreements, though there are still many loopholes which we find when the matters go into litigation. The other aspect which I really feel now in this day and age, and we have been insisting, and I mean we have been propagating, particularly as a chamber, as PhD Chamber of Commerce, is that having institutional arbitrations. We have been, the Prime Minister of India has also said time and again, the Chief Justice of India, successive Chief Justices have said the time has come that we now institutionalize arbitrations and take it to institutions who would be there to assist and who would be there, which would also make it cost effective. So at the PhD Chambers of Commerce, we have, the unique thing that we have put together at the chamber is we have set out our own rules and regulations. We have set out the clauses, the fee structure in consonance with the Act, so that MSMEs or even other institutions or institutions like the National Highway or any of the bigger ones can look at institutional arbitration and have the arbitrations at the chambers. The other thing which I have propagated, and I think most of us lawyers have been in the recent past been talking about pre-litigation mediation and mediations and the clauses of these mediation and pre-litigation mediation in the contracts itself. And this is something which is, again, under the Commercial Courts Act, it has been made mandatory. The courts have now also started pushing matters for mediation. And not only that, I think at the National Highway or even all the other institutions, they have their own mediation centers or dispute review boards or dispute resolution committees, who look into the matters within the institution first, and then if that doesn't work, then go in for arbitration. So I strongly propagate the fact that whenever a contract is drawn, an agreement is made, the concept of pre-litigation mediation should be first attempted, then a clause of arbitration should be put in. The other thing I strongly propagate is the fact that you must have, apart from our honorable retired judges who are very good arbitrators, but we have seen that they are always overburdened. You must look at lawyers, experts in the domain, in those domains where you have arbitrations, to be appointed as arbitrators or co-arbitrators, because they have more time, two, they have equal knowledge of the legal procedures, and they are far more accessible, far more reasonable, and it helps smaller companies, particularly the MSMEs, to have, apart from retired judges as arbitrators, lawyers or domain experts to be appointed as arbitrators. I strongly feel that. The third thing which I really want to also emphasize is on accountability, which is something which is lacking when we have these kind of contracts, or if things go wrong. When you have a good relationship, everything is fine. But when you have the things go wrong, there is no accountability fixed on any of the officers or any of the people in the institutions, which really creates a lot of litigation for the companies. So I feel accountability is something which one must work on when we are drawing up the agreements. Accountability is one big issue which should be looked into. As has been said, as we all know, with the amendments which have come in the Arbitration and Conciliation Act, the time has now been reduced. 12 to 18 months is when the arbitration disputes are required to be settled. And I'm sure Alok ji and Kadamri would be speaking more on about the act as in the clauses and the drafting procedures. But yes, the awards have started coming faster. There is shorter time span. The Supreme Court and the other courts have definitely kind of now, put the stops and clogged the wheels where delays were being taken, were happening for, realization of the awards. The courts have come down very heavily and very clearly and said that no, the awards should not be challenged unless it's completely contrary to law or contrary to, or complete bias is there. So your grounds have been reduced. So that's a very big step, I think, and the Supreme Court keeps evolving the act time and again. Of course, we do have still some gray area and some loopholes in the act, which I think they are now considering. The government, the Ministry of the Corporate Ministry is considering those to see how to plug those loopholes. But there are some loopholes which need to be looked into. But I think overall, uh, we are, managing to reach a point where we are also being considered as a good seat for arbitration, as is Singapore or London or any other of the countries. And I think the more we go in for institutional arbitrations, the more accountability and credibility will increase for our seat of arbitration. The last point which I do want to point out, which I mean, I think with special reference to what Sudhir ji said, was about that most of his matters and most of the matters which they do go end up in arbitration. And I do want to point out to Sudhir ji. Sudhir ji, you of course would be knowing, or I'm sure some of our speakers would speak about Med, which is another form of settlement, that in case you are already in an arbitration and you feel there are certain aspects which could be settled in a mediation, or both parties would be agreeable to settle in a mediation process, you can always, even while your arbitrations are going on, can go in for mediation. If some of the issues get resolved in mediation and the rest are still not resolved, you can come back to arbitration. That is, of course, a cheaper um process which is faster, and it also is a win-win situation for parties in most cases. So of course, hardcore arbitrators and hardcore arbitration lawyers do not would not like me saying this, but let me say it is in the interest of the litigating parties that matters get settled, and that's how the credibility in the commercial area is made, and that's why we are able to have more output in your work if you have your less disputes going on in your companies. So having said that, I think I leave most of the other aspects will be covered. I've seen the program very well by the other speakers. Thank you very much, Dr. Mehta and Sudhir ji and Bhavna. And I'm looking forward to hearing the views of my other friends. Thank you.
Thank you very much, Priyaji, for your perspective. I mean, you have brought out a very important point that pre-litigation mediation center or talk, the some kind of one line can be added in the contract itself, right? This is what you mean. This is a very important point before it really goes for arbitration, and also institutionalization of arbitration is extremely important. These are very good points that you have brought out, and thank you very much for joining us and giving us this perspective on today's webinar.
Thank you.
Yeah. Now, ladies and gentlemen, I would like to invite Ms. Kadambari Singh Puri. She's advocate and also friend of mine and standing counsel NHAI and co-chair of PhD Skill and Entrepreneurship Development Committee, where she gives the legal perspective for the committee and its members. Over to you, Kadambari.
Thank you so much, Mr. Mehta, and I thank PhD CCI for having me over for this excellent session. I can see, from the perspective shared by the other esteemed panelists, especially Mr. Sudhir Hoshing, that NHAI is in the firing zone. And I appreciate the philosophical perspective given by Mr. Ashish Vik. And Ms. Hingorani ma'am's, she's senior to me in the profession, and her experienced legal perspective that she has shared, especially with regard to how now Med is the way to go forward. Ma'am has also underlined how India has emerged as, the new arbitration hub, or rather is emerging with the new landmark judgments that have come about. As far as my being the standing counsel for NHAI is concerned, I will probably say a few words in defense for NHAI also, going forward from what I've heard from the other panelists. So as a standing counsel for NHAI and various other government organizations, and having also represented many private infrastructure companies, I've had the opportunity to deal with fairly large arbitration disputes and legal questions arising out of the Act. Now, to start with, I would like to share NHAI's peculiar experience with arbitration and also other forms of dispute resolution methodologies. Way back in 2013, when arbitral institutions were still coming up in India, NHAI institutionalized their arbitration process to deal with their disputes, hoping to have a very cost-effective and a time-bound kind of solution to their rising disputes with the private developers. However, I will say that by 2019, the authority saw itself facing inflated claims worth 5,000-6,000 crores. By 2019, that was the quantum of claims that we were facing, and a majority of such claims were being allowed by the arbitral tribunal. Now, to curb this, NHAI recently had set up conciliation committees, conciliation of independent experts, CCIE as we call them, and they have worked on a very fast track mode to resolve a majority of disputes through conciliation. And from about 108 cases which have been referred to CCIE, by June 2020, now it would be even more, from about claims of 13,000 crores, less than 10% claim value in that less than 10% of the claim value, all these disputes had been settled. So most of these claims have been highly inflated ones, sought on idle labor and machinery charges. And I will revert to this particular point by citing some of the judgments which have taken note of this fact, that about all the claims being raised on idle labor, machinery charges, and similar other heads. Now, in this context, I would like to mention the recent ruling of Delhi High Court, which has come down very heavily on the practice of various private developers raising huge claims, sometimes 5 times the contract value or more on non-substantial grounds. Now, the Delhi High Court held that suffering damages willfully and recklessly, when you don't have the land, you still put up the labor, you still put up the machinery over there, when the contractor knows that the land is not unencumbered. So it will not inure to him any benefit. In fact, several courts rather now, following Delhi High Court's example, have held that awarding inflated values does not amount to anything short of a fraud on the legal system. So, in cases where the developers have claimed exorbitant amounts on labor and machinery idling and other such reasons, the High Court has said that the developer has to survey, and it's noted in the contract also, to survey the areas where they need to access. And it is obvious that any prudent man who is making a bid with ordinary diligence and has to inspect the site. And if he still finds, even after being awarded the contract, the developer finds that the land is encumbered or it has issues, it should not put up the labor, or should not put its efforts, and can ask the authority to delink that particular part of the project. So it cannot go ahead and willfully suffer damages by deploying any purported labor, etc. Now, in this particular case also, the Delhi High Court had set aside the arbitration award, which had allowed all these heads. Now, since the time is short, I will probably just like to recount some of the key essential legal points. As Ms. Priya Hingurani had mentioned, that we can cover some of the judgments and some of the legal points pertaining to the new amendments which have come about. So I will just take some time to mention a few of them. For the benefit of the audience, who I presume will be mostly from the private sector. So point number one that I can think of is the price adjustment mechanism, because this has been the subject matter of a lot of cases and disputes between the private developers and the authorities. So the courts have held that the private price adjustment mechanism, as contained in the contract, cannot be overridden by subsequent circulars or subsequent executive action. So this part has been taken care of by the court's rulings, because there have been instances where, including NHAI, several authorities try to come out with a new executive circular, and then it is sought that the price adjustment mechanism is sought to be based on that, rather than what was contemplated at this execution of the contract. The second point that I wanted to mention was that an arbitration clause can be invoked by an aggrieved party even pursuant to execution of no objection certificates or discharge vouchers or waivers. I'm sure this is one of the issues which a lot of private players are, beleaguered with. They're usually there are issues on this. So this point also is largely settled, except that the credibility of the plea of coercion has to be seen by the court. So if your documentation is in place, this becomes an easy task for you to achieve. Then the other point that I would like to share is that where your company, yours is a parent company and is a non-signatory to the arbitration agreement, still you can assert the right to participate in the arbitration proceedings. So this is again a recent judgment, MTNL versus Canara Bank, where the court has invoked the doctrine of group of companies and has permitted even non-signatories to an arbitration agreement to participate in the proceedings, where the non-signatory can be held to be bound by the arbitration agreement, or it has participated in the signing of the agreement in the first place. The next point I would like to mention is regarding a named arbitrator. So there have been recent judgments which have really changed the entire framework of arbitrations in India. So these two being TRF versus Energo, and also Bharat Broadband Network Limited. So in these two cases, the Supreme Court has recently held that even if you have a named arbitrator in the contract, still you may now require consent in writing by all the parties post dispute. So if the agreement is there, you've agreed to a particular arbitrator, the authority to appoint, etc., and various other clauses are there. The chairman has to appoint, or some employee has to be there. However, now as per these two landmark decisions, you have to seek the consent of the parties post dispute. Otherwise, one party, if it challenges, this can be set aside. Uh, the seat of arbitration has been a subject matter in a lot of disputes, and seat of arbitration, now it is fairly settled, will be decided as per the seat of arbitration will be determining the jurisdiction, even where the law governing the main contract differs from the seat. So, in fact, this is in consonance with the international law also. And there are a few points on limitation. A lot of people, take up an issue about the arbitrator being appointed on the ground that there is no limitation, but this also has been left to the arbitrator so as to give complete autonomy and impartial, complete autonomy to the arbitral agreement. So in all these cases, as we can see, whether it is claims on various charges, or whether the authority is to be blamed, or the private party has been not complying with its contractual obligations, it is usually found that it is the document management in an infrastructure contract, which is the most essential point. And normally in a construction and infrastructure contracts, the damages are claimed by parties on the basis of delays attributable to the other party, variations to the main contract, and the quality of the work being executed. So these issues can, of course, be effectively proved from the emails exchanged, the communications that you have kept, how you've kept those communications properly indexed right from the negotiations. This can be of a great help at a later stage to prove your claims. I think with this, these are some of the points I just thought would be relevant to the audience. Thank you so much.
Thank you very much, Kadermi. You have really defended NHAI as a standing counsel with your legal prowess with grace, and made some very strong points that that were raised initially by Sudhir Hoshing ji. And thank you very much indeed for bringing out a new perspective to this webinar. And now, in fact, we will have the Q&A after the remarks of Mr. Alok Krishna Agrawal, who is the chair of our legal and ADR cell. For the information of all the participants who have joined today, let me tell you that we have a arbitration and dispute resolution cell at PhD Chamber of Commerce and Industry, which is right now chaired by Mr. Alok Krishna Agrawal, a very renowned luminary, legal luminary. So now over to you, Mr. Agrawal, for your concluding remarks and your other remarks for this whole session that has been so far processed.
Many thanks, Dr. Mehta, and thanks to all the distinguished guests, colleagues, and delegates, as also all those who have graced this occasion and this conference. Now, just to recapitulate and remark on some of the thoughts that have been put forward here. Mr. Sudhir Hoshing had at the initial put two very important points before us. One, that it is the same contract and it is the same very issues which continuously haunt us. Now, this same contract and same issue is not only a difficulty, but also gives a solution. If the contract is the same and the same issues are arising all the time, then perhaps it is an indication to a solution which is very much there. We have been in a lot of cases for Inland Waterways Authority, as also some international infrastructure companies. And I would like to place before you some practical aspects of what happens every day. Now, what are the kind of disputes that we normally see in all these infrastructure projects? As has been put by Sudhirji, the land is not given. The idling time is there, it creates. Then on the various other force majeure issues may be there. There may be other aspects relating to government orders. There may be aspects with regard to site conditions. There may be aspects with regard to some labor unrest. There may be aspects with regard to drawings not available on time. Now, these are the basic, issues which time and again keep cropping up all the time. Now, is there a solution to this? If there is, then at least we should try to look into what can be a solution. Now, the same contract, NHAI, the same contract, IWI, the same contract, a lot of infrastructure companies are continuously going on and on with the same contracts. Now, in one of the cases, I found that there was a departure from this standardized contracts. Now, what was the departure? And I'd like to place it before you. The departure was that there was an appointment of a continuous dispute resolution officer. Now, what do we actually mean by continuous dispute resolution officer? There was a proper person who was authorized to call both the parties, or if there are multiple parties, more than two parties, on all days, and in a segmentized manner, ask them if there were difficulties, and if there are, then on a daily log, it would be entered as to what the difficulties are, and if it could be resolved at that level. So we have here what is called a segmentization of a contract over there. Now, not only was there a segmentization of contract, I also found in the contract that there were itemization of the contract and there was a calendarization of the contract. Now, segmentization, itemization, and calendarization, these were the key aspects. And it went a long way. I must place it before you. Now, what do we mean by calendarization? As was stated by Kadambari Singh ji, that even if the land is not available, it is seen that the contractor brings his machinery in. Now, if there is a calendarization of the contract, and if each and every day is marked over there, that look, every day has a value attached to it. So on calendarization, if you give a valuation to each and every day, then at the time of arbitration, it becomes much easier to decide for the arbitrators. So if you are entering into a zone which is still not ready, then, and you have entered there for about 20 days unnecessarily, then calendarization will ensure that for those 20 days, there is a cost involved. So these three aspects which I thought I must place before you, that if the contracts today get into a new kind of a drafting, including itemization, calendarization, and segmentization, then perhaps we may have a solution to this repetitive issues coming about. In all the infrastructure disputes, we have always seen only these repetitive issues coming to the force. There are never new issues coming. The issues, I must repeat, are again those which haunt us all the time. Is labor unrest may be there. There may be government orders and circulars. Drawings are not available on time. Then site conditions are not proper at that point of time. Or there may be situations when there is a variation in the original design. Then there may be situations when the raw material is not provided at the right time. Insurance is also an issue which crops up. Then fluctuation of prices, force majeure, especially in COVID times, is going to be an important aspect, as also health and safety. So basically, if in all, there are about 20 issues. Now, if each 20 issues, given the experience that the legal community has, if these are placed, then perhaps the contracts can be drafted. Then Ashish Vigji, in his lyrical best, as always, stated that at the end of the day, we are partners in the project, and there has to be a trust. No doubt there has to be a trust, but then the disputes don't arise only because the trust is in this place. The dispute arises because the bedrock, the contract, is not properly drafted. So I come back to the contract again. The contract, if it is drafted in a detailed manner, forcing each and every dispute which is going to arise. We don't do dispute-wise contract drafting here. We don't. We do the drafting as it has been drafted. It is being drafted for a very early time. So dispute-based drafting, segmentization, itemization, calendarization, these are the new developments in the contract drafting, which if we bring in, perhaps the arbitration can be better served. We had here PI Ingurani. She very ably and forcefully guided us through the benefits of MEDA. In fact, she has been a person who has single-handedly built the ADR cell here in PhD. And the template that she has laid down is the template that we are now adhering to and following. Our ADR cell here is, I may say quite boldly, and the infrastructure and everything is a kind of a dispute resolution mechanism which we have set here is something which is extremely cost effective. It is time bound and it is transparent. So if the members of PhD would include the standard arbitration clauses that we have here, then perhaps they can avail a lot of benefit of having their disputes resolved here at the PhD. Now, insofar as the other aspects, I would not go into the arbitration laws and the recent developments. No doubt Bharat Broadband is a leading judgment over here, and Bharat Broadband, TRF, Bharat. Both of these judgments, in a way, give a sort of an equitable relief to both the parties. I mean, you are not saddled with a particular arbitrator, even if he's named. You can still go and get another arbitrator who you think at the beginning. See, the arbitration is all about you're having a trust in the person who's going to decide your dispute. So therefore, it was in the fitness of things that an arbitrator should be somebody on whom both the sides repose their total and absolute trust. Kadambi ji here said in a very, very forceful, in her very forceful presentation in defense of NHAI, she said that, look, NHAI has tried its best to have the disputes sorted in a separate, in a separately devised platform where with a separate set of people. The same thing was also tried out at Indian Waterways Authority here. But similarly, as what she said, similarly is the experience here at IWI. At the end of the day, I would say that if our contracts are drafted in a, I'm again stressing only on this contract drafting. I've always found that the contracts are drafted in a slightly more practical manner. You see, every infrastructure contract is bound to throw open some disputes. Now, disputes are always repetitive in nature. If the disputes can be given costing for delays, if the dispute can be identified at the beginning and each dispute handling could be given in a particular manner for each project, perhaps we can have a better way out. I would only like to conclude by giving my thanks to the leadership of the PhD, as also to Dr. Ranjit and all the colleagues for giving me this opportunity to be before you.
Thank you very much, Mr. Agrawal. As always, you have summed up with a lot of, you have interpreted every question that was raised and query and commented on the issues which needed some comments. And thank you indeed for joining us today for this very important webinar on arbitration norms for infrastructure sector. Now we have one hand raised, Mr. Vinod Shah. He wanted to ask some question. Admin, can I ask you to unmute Mr. Vinod Shah? He would like to ask his question. Mr. Shah has also written his question out here. He says that the unilateral way of agreement is big point. Although international contract has adjudicator, even then arbitration process is very common. Why? So this is the question. I would urge experts to actually, if you can just answer the question, which is there in the chat box as well, Q&A. Anyone may.
Now, insofar as I take this up,
Yeah,
insofar as the international contracts are concerned, there is no doubt when there are two parties, one is an institution, that the institution is always in a position of dominance. There is no doubt about that. This position of dominance, howsoever you may try, you cannot, you know, weaken it or dilute it or water it down. Having said that, it is now the experience of all these institutions that a dispute serves nobody. It is also the experience of these leading institutions that at the end of the day, they also suffer a lot because of the disputes. So what is happening now is that various institutions and various uh, authorities are taking um, at the time of awarding the contract. There is always, as you know, that there is always a session where in those sessions, if you put in your questions about certain aspects, then those aspects are brought into a contract. That contract always helps both the parties. So whenever you apply for a tender, pre-tender stage, there is always a questioning session. So in those questioning sessions, if you have issues, you must bring in. It is all very good to say that here is an institution and it is in a position of dominance. But yes, that dominance, if you bring and show reason to them that, look, this will raise a dispute, then those things are definitely brought in. Now, insofar as adjudicators are concerned, international adjudicators are concerned, it is the same aspect. You see, here in the arbitration laws that are there here in India, as well as they are there, there is, as Priyaji had said, there is a pre-arbitration, there is a mediation exercise. Now, mediation exercises are built to help both the sides. So if we go for a mediation exercise before the disputes, then definitely, and those contracts, wherever you find that mediation is not well set out, normally I would always see that mediation aspect is there. It is not merely a formality as some of us feel. Mediation exercises do give results. In fact, there is a lot amount of data on this mediation exercise, which is giving a lot of relief. As a regular arbitrator or a regular arbitration counsel, we feel that sometimes these mediation exercises are mere formalities. That is not the case. So even in these dominant institutional arbitration clauses, mediation exercises should be resorted to.
thank you, Mr. Agrawal. I'll just take one more question, though there are other questions in the question and answer chat box. We are just short of time. Maybe that I'll just take one more question of Mr. Krishna Rao. Who he writes whether the clause in arbitration agreement that nominee arbitrator will become sole arbitrator if the other party not appoint his nominee arbitrator is valid as per the recent SC decision on appointment of sole arbitrators by a party. So is it a question or it's answer in itself?
Yeah, that's what probably the question itself has an answer,
Yeah.
because what the gentleman wants to say is that if there is already an appointed arbitrator, which is the nominee arbitrator of one particular party, is that correct? Perhaps he can further clarify. As per TRF and broadband cases, uh, again, a consent is required in writing as per the latest view of things.
Okay. Thank you very much to all of you, Ms. Priya Hingurani, Ms. Kadambari, Mr. Alok Krishna Agrawal, and Mr. Sudhir Hoshing. Mr. Vig is also going to be here. And thank you very much indeed for your time and the kind of knowledge that you have given in this platform today to all our listeners who are here, who are attending this webinar. Now we have a panel discussion which will be moderated by Mr. Arjun Chaudhary, This is a multi-party arbitration in infrastructure disputes. And Mr. Arjun Chaudhary, senior journalist and mediator, Delhi Dispute Resolution Society (DDRS), Delhi Government Mediation and Conciliation Center. Over to you, Arjun, for taking the next session, and please call the panelists as well. Thank you.
Thank you so much, Dr. Ranjit Mehta, for giving me this opportunity to address this panel of distinguished speakers. Now it's the turn to move on to the next lot of speakers who will enlighten our participants about the challenges in the infrastructure sector, what kind of ADR process is to be implemented, and what we were able to realize from our distinguished speakers earlier was that conciliation could be a way forward, especially on a day-to-day review of what's going on and resolving disputes. But we also had those who spoke about mediation as an alternative, along with the adjudicatory process of arbitration, so that cost overruns and time delays are not incurred in infrastructure projects. So hopefully in the next presentation by distinguished speakers, there is an addition of value to it. And we will start this session on multi-party arbitration in infrastructure disputes with our panelist, Mr. Gautam Bhatikar, who is a partner with Phoenix Legal. And Phoenix Legal has been kind enough to sponsor this virtual session as well. So thank you so much. We also joined by Mr. H.K. Sarma, Joint General Manager, Legal, Larsen & Toubro, IDPL, Mr. Atul Nigam, Partner, Chamber of Nigam and Nigam, and Dr. S.P. Saraswat, Managing Director, Global E-Auctions, founder of Global Society of Arbitration Support, and Chairman, Indian Institute of Plant Engineers. A warm welcome to our panelists to this virtual conference. Now, before we begin, I would plead with our esteemed panelists that we have to keep time, because we have to wind up within a certain time frame. So I would request that each panelist take up about 8 to 10 minutes in their presentation. And we would like to begin with the presentation of Mr. Gautam Bhatikar, who is a partner with Phoenix Legal. And before he begins, I would just like to introduce him briefly, that he has extensive experience when it comes to public-private partnership projects and its financing of ports and terminals, also dealing with arbitral disputes when it comes to international shipping and logistics across the arbitral institutions like SIAC, ICC, LCIA, LMAA, and SCMA in Singapore and London. He has a dual qualification in India and England, which gives him the license to practice in both jurisdictions. So I'm sure his presentation would enlighten us as to the challenges in the infrastructure sector and how we can overcome them. Over to you, sir. Thank you.
Thank you very much. Well, thank you for having me here, and it's a pleasure to be here and speaking before distinguished guests and distinguished participants here. Well, I will largely touch upon how the arbitration over the years have evolved, and as dispute mechanism in India. I would also maybe briefly touch upon the multi-party arbitrations that everybody is talking about and where India stands as of today. Largely, the other issues that normally come before multi-party arbitrations is whether a consolidation of arbitrations or a joinder of parties is possible. How and in what way can the arbitration proceedings be conducted in a time-bound manner? Some of the key issues that lead to disputes in infra projects, dealing with time extension and levy of liquidated damages, which is one of the common things that's normally seen in infra projects, on delays and other aspects. Then, in a nutshell, maybe possibly touch upon the challenges to arbitration awards and the impact in general on the commercial side on these delays, as to how the infrastructure companies in India economically face. So coming to the first point on how India has overcome over the years is from the 1940 Act, which was the pre-British colonial era time act, to the 1996 Act, which has now been largely the framework under the UNCITRAL rules and framed in that fashion. Largely, the Act was always with the intent that the involvement of the courts and involvement of the uh, courts to a large extent and interference of courts in arbitral proceedings has to be minimal. However, till in the recent times, when the courts have now decided that the involvement would be very limited. Predominantly in the past, the courts involvement was to a very large extent at every stage, whether it was maybe a Section 9 proceedings, which were preferred over Section 17, so, possibly challenges of the award, which was on the ground of various ground, and rather having the arbitral awards challenged, and would take years together before the courts to eventually decide one way or the other, and multiple proceedings, one after the other, from the first appeal to the second, and so on and so forth. However, in the recent times, with the 2015 amendment that has come up, with strength given to the arbitral tribunal as well under the Section 17, where people are lot following that procedure nowadays, not in the infrastructure per se, but also in commercial disputes that's normally handled. Arbitral tribunal also look at interim award that are required to be passed, which are now largely treated as a court order and can be enforced if at all there is a requirement to enforce. In addition to that, today where we stand in infrastructure as such is there are multiple parties in any infrastructure project, may it be from the principal, which is a government, to a contractor, and there would be number of vendees and vendors and subcontractors. Now, what is the actual need of the hour is having some sort of a mechanism where multi-party arbitrations are taken more seriously, so that under one roof multiple disputes are taken care of or are resolved in whether you follow the mad procedure, or whether you follow a purely arbitration proceedings, or you follow a conciliation arbitration proceedings, or any other mechanism. But what actually is a miss is a multi-party arbitration. Giving an example is when there is a dispute between a principal and the head contractor. The head contractor would normally has to face the brunt, even though the possible delay may have happened due to a subcontractor's fault. So his exposure is normally larger as compared to any other subcontractor. So if the subcontractor contracted and the principal come together in a multi-party arbitration, whether it is done by a consolidation or by joinder of parties, or in any other mechanism, I think what is very much essential today is we need to come forward, or the legislature has to come forward to come out with some rules as to how multi-party arbitrations are to be dealt with. That's very essential in today's world. Otherwise, you will have two arbitrations on the same subject matter running parallelly, or may not be running parallelly, or may run one after the other, which eventually would have somebody exposed much larger for no fault of his. This has been largely covered in most of the international institutional arbitrations, like SIAC or ICC or LCIA, which is the ICC, the International Chamber of Commerce, or LCIA is the London International Arbitration Center, or SIAC. They do have a special provision within their rules on multi-party arbitrations and joinder of parties. This is something we may have to take back home and ponder over and see as to how this can be dealt with in a larger sense. the effect or the advantages would be largely the time would be saved and the cost, because the time not only on the project but eventually recovering the money from the project that has been completed or whether delayed or otherwise is the exposure of the contractor and the subcontractors and various other vendors for that project if they are unpaid, and that would eventually lead to not only a cash crunch but also may lead to closing down of establishments which have normally been seen in infrastructure projects. So that's something which is very important when it comes to consolidation or getting arbitrations together to deal with at one time. So there has been a time frame that has been already decided by the act, that's a 12-month plus 6 months by intervention of court. And there have been multiple proceedings that now have been kindly largely stabilized to the extent that the appeal courts are not simply admitting any matters the way it used to be happen in the past. So largely the matters are now being looked upon more seriously and more critically as to whether this appeal from the award has to be admitted or not. At the same time, even though there are issues to that effect, even though the matter is admitted, unless there is a stay in the proceedings of the appeal, there is a possibility to go ahead with the execution of the awards if there are such awards passed. Now, the key issues normally that come forward in any of the projects or the arbitrations or the cases relating to disputes per se in infrastructure or projects for that matter are normally delay in completion of the project or possible liquidated damages or variations when it comes to extension of time, rights and liabilities of the parties. Well, in all these aspects, while our previous batch of speakers did speak about these cases are very repetitive, and it has to be so because if you're a manufacturing unit and if your product is damaged, you're going to have this kind of repetitive cases every now and then. It's just going to be the same in infrastructure projects as well. There would be very specific projects or disputes that arise of infrastructure projects. Like there would be a delay, there would be maybe a wrongful termination if there is a possibility, or there is a breach of contract, maybe by the contractor or maybe by the principal to some extent, or withholding of bills, non-payment of bills. Largely, there's one more issue that normally is used by most of the principals is the threat of invocation of bank guarantees. So at times you have the bank guarantees being invoked, sometimes wrongfully, sometimes rightfully. Most of the times when the bank guarantees are invoked, the law of bank guarantees is fairly settled. Unless the party going to the court against the invocation of bank guarantees is in a position to demonstrate on a prima facie basis that there has been a fraud or there has been a irreparable damage, the courts are reluctant to grant injunctions or stay on invocation of bank guarantees. This has been largely the complaint of several contractors or several developers for infrastructure or projects implementation companies for facing bank guarantee invocation at multiple times. Their also contention is that as soon as the bank guarantee gets invoked, the banks don't look at it very positively for their future financing. So that's again the issue that comes up. So I think more ideally the two things that play a very important role. The first one would be, while the contract is in place and most of the infra projects are granted through a tender, the contract per se is already in place. So the best thing what the head contractor may want to evaluate is the possibility of the contracts with the vendors are in line with the main contract, and there is a possibility, or there is a clause which allows some sort of a joinder of the uh, subcontractors into the main arbitration, which then would have parallel arbitrations going forward. So in
Mr.
large,
Gautam Bhatikar, sorry to interrupt you. We are running a little out of time. If it's
sure.
possible for you to wind up in the next minute, I would be very grateful so that
No, I'm
the
about to
other
wind up. I
speakers
think
can also participate.
yeah,
Thank
I'm
you.
about to wind up. Thank you very much. So these basically largely the project delays and other things that come on the way. So in addition to what I have said, so that there is something that is very essential, and which has been the main topic of our discussion today, is on multi-party arbitrations, and that's today is the need of the hour. And if the multi-party arbitration is brought within the act or within the rules that are required to be dealt with here in Indian arbitration, the time is not very far to not have India as a strong arbitration hub for Indian seats to deal with international commercial arbitrations, and also give rise to the larger FDIs that would come in India, because most of the FDIs do look at the infrastructure of that country more seriously at a time of making such FDI investments. With that, I thank you very much for having me here, and over to you, Arjun.
Thank you so much, Mr. Gautam Bhatikar, partner Phoenix Legal, who was able to summarize the challenges in multi-party arbitration. In infrastructure disputes, we spoke about how concurrent matters may be created, and of course, the threat of invoking bank guarantees. Next, we have Mr. Atul Nigam, partner, Chamber of Nigam and Nigam. Mr. Nigam, it's up to you now. Continue.
Thank you so much. Mindful of the time. In fact, the panelist who was before me, my friend Gautam, happened to sum up extensively on the various aspects of the infrastructure arbitration is concerned. I need not devote time on that. I'll basically pick up from where he's left. This is in respect of the theme which we have asked to basically throw light on is on the multi-party arbitration and infrastructure disputes. Now, as the word by themselves expresses very clearly that there are multi-parties involved, and with involvement of multi-parties, there are going to be multi-party agreements. What does this all means? In fact, the role of a practitioner only comes when a dispute is there, not otherwise. Otherwise, it's in the hands of the people who basically are drafting, or maybe at the stage of drafting, you may call them some. Now, what we are talking about infrastructure projects means it's basically involvement of state, the private players and the public players. Now, when we have such a team of stakeholders involved, what does it really call in for? It basically calls in a stitch in time saves nine. I believe the opening remark of Mr. Sudhir Hoshing was only in this direction. He wanted to basically save the industry the time they spend in disputes. They said rather devote time in the development of the projects. So, sir, I will only look at the key issues which trouble this aspect of infrastructure arbitrations. And these can be very well taken up. They've been taken up by the panelists. I just want to devote a little attention on them. They can be divided into three parts. The first pertain to the arbitration clause. Second is your national law, or basically your law which deals with these problems. Thirdly is the basically setup. When you take up these arbitration disputes, to whom do you go to? You basically go to an arbitral tribunal. So all these three issues are interconnected, but the backbone of the entire aspect is your arbitration clause and the arbitration system. What we are basically missing the point at the moment is to look for the exact problem, where exactly the problem is. From a disputant point of view, the problem is that he likes to have all his disputes resolved in a single arbitration. In an infrastructure arbitration, we don't have that. We have individual players. We have their individual disputes. We can't bring them as far as into one arbitration. Why is it? It is not a judicial system that we start to compare arbitration with. It is basically based on consent. It is based on autonomy. It is the parties who basically select a dispute resolution mechanism. When you have that, the consent will always be amongst the contracting party. How would you have a third party? If I were to identify other parties, basically they may be subcontractors, they may be the other contractors, or they may be basically in some form of a guarantee contract in which I'm involved with. How do I bring them as far as in the one arbitration? That is the key issue. The key issue is because it basically helps us in saving cost. It basically helps us in not having conflicting decisions. There is a time schedule bound under the statute wherein you got to complete this entire exercise. And then the basic question is, you are in combination meeting out the expectations of the employer. And in most cases, the employer is the state. One should recognize the fact that the state is basically calling in for these infrastructure projects as creating as a resource. We as a contributor to this creating of the resource, it becomes a duty also to protect these resources. So of course, as what Mr. Ashish Vig happened to speak of, the trust factor. The trust factor is basically starts to begin from the point when all these stakeholders basically join in their efforts and they're able to, if ever they have a dispute, they can resolve it together. I would not have to chase in another arbitration. My subcontractor would not have to chase another subcontractor in another arbitration. So it is basically a string of arbitrations that we get into. And the project is labeled as a project which is basically troubled by disputes. So how do we come across? This is the first aspect that we need to focus on. When we draft or basically when we have an arbitration clause, we should have the provision of introducing multi-party and multiple contracts into that arbitration. That is a basic, without which you will not be able to step forward. The second aspect is, for any system to work, is basically to have, and typically when we talk about dispute clauses, it is to only work on the national laws, nothing else. So what we have in place today, we have a fantastic system of laws. Starting from 1940, we had an Arbitration Act, which carried on. And then finally, we had an Arbitration Act in the year 2015, followed by a Commercial Act. And then we happen to have an improvement and an amendment in the Specific Relief Act. What does it basically talk of? It basically talks of a system that is being provided. Specifically, there is no system prescribed under the Arbitration Act to resolve this issue of multi-party and multiple contracts. Then how do we resolve this? Again, the question comes back and basically faces us. The need of the hour is that we should have some improvement in our national laws, whereby in case a party misses out on these contractual aspects, it could be introduced through these national laws or in a manner in which, yes, a progress can be made. Of course, a helping hand is basically given by the courts in India today. You always approach the court and seek a help that I require to consolidate, or we need to have a joinder of parties in it. Now, what is the court looks at basically? Court looks at what is the continuity, what is the relation, what is the common relation amongst these parties, which is an important factor to unite them and bring into one arbitration. But there are certain deficiencies associated with that, irrespective of the court also intermeddling. The fact of the matter is, in respect to the consent, consent says in arbitration means, can you appoint your own arbitrator? No, you can't have your own arbitrator because it's the court who's appointing the arbitrators. It is the court who's basically setting down as to what is the scope of your arbitration is going to be. So as far as party autonomy is concerned, party autonomy normally in such matters is given a secondary. Now, the third aspect, which I'll basically come to, with my friend Priya Hingorani also spoke of, as far as shift from ad hoc arbitrations to institutional arbitrations. It is very important today, as when we look at that there should be an introduction of institutional arbitrations in our arbitration clauses. Why it is? She happened to dwell on the fact, yes, it saves us cost, we have specialized mechanism, etc. How does it basically deal with institutional arbitration in respect of the multi-party arbitration? Why it is so important other than the ad hoc arbitration? Answer is
Mr.
very
Nigam,
simple.
sorry
Yeah.
to interrupt you. Could you?
I am summing up, my friend.
I will be very grateful. Thank you so much, sir.
I'm running it fast. That's why I'm sorry. I'm running it fast. The institutional arbitrations, most of the international institutional arbitrations and the institutional arbitrations which are set up in India today, they have a mechanism for multi-party systems. So all that we need to look at is we need to correct from the time we enter into our contracts to the time we are entering into the dispute arena. If we are able to sort that out, to take my word, as far as your redressal system is concerned, that empowers you to come out of it, to hold you into a single arbitration under one roof, as what my friend Gautam happened to insist on. So we can have some resolution on all inter-se disputes on that. So thank you so much. Thank you for giving me an opportunity. Thank you so much.
Thank you so much, Mr. Atul Nigam, partner, Chamber of Nigam and Nigam, at the lucid manner in which you explained that all the issues cannot be resolved by arbitration. You can change your tactics into other ADR processes as well, and also the distinction between institutional arbitration and the sole arbitration. Now, let's move on to our next panelist. We are joined by Dr. S.B. Saraswat, Managing Director, Global E-Auctions, founder of Global Society of Arbitration Support, and Chairman, Indian Institute of Plant Engineers. Dr. Saraswat, welcome to this virtual conference on multi-party arbitration on infrastructure projects. My humble request to you, sir, is to keep it as brief as possible. If you can keep the time frame of 6 to 7 minutes, I would be very, very grateful. Thank you.
Thank you very much. This is my pride and privilege that I have been invited as a speaker on this August gathering. And I would like to make a small presentation. And I think Mr. Ramesh, could you kindly give me the control?
Sir, the control is with you.
Okay. Yeah, so I welcome all the delegates and panelists. And I would like to touch upon something different from what has been talked all around. In fact, I had the privilege to work as an employer for almost like 2.5 decades in the senior most positions of largest organization of this country. Also, I had an opportunity to work on other side of the table for almost 15 years as head of the company, multinational company, executing largest projects of this country in the steel sector. And therefore, my depth and my understanding about the disputes is entirely from a different perspective. And therefore, I have a small presentation which brings you to a different forum. I would like to request you to kindly think that unless we understand the issues, as the name of this webinar is the arbitration issues. And the arbitration issues are really critical and very important. But arbitration is the final, or maybe legal fight is almost the final. But the question comes that why arbitration? Is the arbitration is only the target of the disputes, or something better than that is available, is something which I will bring to you. In fact, I am looking for certain actions which bring you to the corrective actions, and that is prior to the arbitration. As all of us know, the disputes are on increase in a multiplied manner, and there is a call that we must look for prevention and correction of these disputes rather than looking for ADR for the resolving this. And therefore, my presentation will be basically resting on certain suggestions, recommendations, and also some ideas how the various kind of disputes are generated. I would like to share with you that if you can compare the contract system of Indian construction contracts, then you'll find that FIDIC kind of contracts are much better. This is a sweeping statement I am making, and I hope I will be in position to correlate this with subsequent presentation. I also know that infrastructures are very important. If you look at importance, then around 40 million people are employed by this sector. And also the GDP contribution through this infrastructure project is almost highest next to the agriculture. And it generates a lot of employment, and business and trade is also increased. And it is also very important that the disputes basically devast the progress of the country and economic growth. And therefore, it is our first target that we must prevent the disputes and we must avoid it. But what are the methodologies? What are the reasons? What are the ways how we can really do it? And why it is happening so? In nutshell, there could be many, many reasons, but fundamentally, the inappropriate contracts are the reasons for generating disputes. And also the delays. I can tell you, delay is the prime reason to generate the disputes. And therefore, we need to see that the contract management is improved, reforms are done, and delays in large projects are curtailed. I would like to cite a very specific example, typical example. And I think all of you can see very transparently. I will cite you few examples that how wrong contracts are being formed, being executed, and finally the disputes are being generated. You can see the first example. The employer asks a lot of things and finally doesn't hold himself responsible. How is that? You ask somebody to do the job and you don't support him, don't take the responsibility, don't have the trust, and don't carry with him. And this is not the way you can execute the large projects in isolation. The second example is also alike, that they will approve all your schemes, technical documents, and all technological related documents, but finally they will not hold themselves responsible. If so, who and why you were looking for this kind of approvals? Why you were creating so much, why you were investing so much time on these things and taking the time of the contractors, and you're wasting your time. The third example also is falling in the similar category, that everything has to be according to the contrary to the good engineering practices. It means, what are those good engineering practices? I tell you, all projects are the creations on this earth. infrastructure projects too. But every project is constructed through the engineering schemes. And if you keep this kind of general statements in your contracts, then I call all the luminaries, all the technical experts, all the legal experts, please have look this kind of contract. And these are not the something which I have made of myself. These all contract clauses are taken from some contracts. So therefore, I would like to again pinpoint that it is not advisable that you create the dispute intensity. I would like to share very categorically that we are creating disputes and then we are talking of resolving these disputes. Why? What for? The first and foremost requirement is that let us cut down the basic reasons of generating the disputes. Your automatically lot of things will be solved and you will reach to a comfortable situation. You see, I would like to cite an example, the extension of the time, EOT. There are 70% of this organization of this country who are never giving you EOT. Why? I heard some lawyers talking that people are making extra and illogical claims. Why not? If contractor has been asked to work on the site and if you don't give the clearance, then no law should be there who should stop making claim. Claim is the basic right of the contractor because he has employed his manpower, resources, and everybody. And I think talking on this line is never advisable, nor appreciable, and nor I think should be according to the law. This is one clause you can see here. How
Dr. Saraswat, sorry to interrupt. Could you please wind up? We are running short of time.
All right. You are too harsh with me because anyway, all right. I would like to justify and I would like to meet your request, but I would like to just take few minutes that there are reasons why the disputes are being created, and this total thing, whatever, right from start to end of the arbitration, I have covered these things in a book which will be immediately, I think, made open. By
Dr. Saraswat, my apologies for interrupting again. If you could share the PowerPoint with the participants, I would be very grateful.
All right.
We're about to be joined by former Chief Justice of India, Shri Deepak Misra. I would be very grateful if you could just wind up, please.
Okay. So let me conclude that first you have to avoid the disputes, and if it is inevitable, then the fighting the arbitration rightly by making a proper delay analysis, having a very logical claim, and finally convincing the arbitrator should be the right job of any contractor or employer, and that is what I would like to urge upon. I'm sorry, the time is very limited. I cannot justify my presentation, but I would like to tell you that there has to be a system by which the arbitrations can be made easy. Thank you very much.
Thank you, Dr. Saraswat, for telling us the importance of FIDIC model contracts when it comes to drafting the agreements. There was some discussion earlier about it also. And now we're joined by Mr. P. Multani of the PhD Chamber of Commerce. I hope I've given the introduction correctly, sir. Do continue. We have very short, limited period of time.
Thank you very much. Thank you very much, Arjun. Thank you very much, ladies and gentlemen. Very warm welcome. We have been joined by Honorable former Chief Justice of India, Mr. Deepak Misra, with us. So we have Mr. Pradeep Multani, Senior Vice President, PhD Chamber of Commerce and Industry, and also the CMD of Multani Pharmaceuticals Limited. But before I invite Mr. Multani, I would like to formally introduce Honorable Mr. Justice Deepak Misra, though he does not require any introduction. But Honorable Justice, Mr. Justice Deepak Misra has served as the 45th Chief Justice of India from 28 August 2017 till 2nd October 2018. Born on 3rd October 1953, Justice Misra enrolled at the bar in 1977 and practiced at the Odisha High Court. He was appointed as an additional judge of the Odisha High Court in 1996 and was transferred to the Madhya Pradesh High Court, where he was made a permanent judge in 1997. In December 2009, Justice Misra was appointed Chief Justice of Patna High Court, serving until May 2010, when he was appointed Chief Justice of Delhi High Court. Justice Misra was elevated to the Supreme Court of India on 10th of October 2011 and assumed charge as the Chief Justice of India on 28th August 2017. As a judge, Justice Misra has decided important issues pertaining to commercial and contractual matters, corporate law, issues in the field of taxation and arbitration. As a judge of the Supreme Court of India, Justice Misra has delivered several landmark judgments. He has contributed immensely to Indian constitutional jurisprudence, and each of his judgments can be said to constitute watershed moments in Indian judicial history for enhancing the scope of golden trinity of rights under the Constitution of India. Chief Justice Misra was part of the bench that struck down the century-old Section 497 of the IPC, considering the provision to be unequal and arbitrary. It was the bench led by Justice Misra that pronounced a landmark ruling lifting the ban on the entry of women into the Sabrimala temple, thus voicing opinion against discrimination against women of a particular age group. Justice Misra has been a strong upholder of constitutional values and citizenry rights and a staunch defender of the rights to equality, liberty, and dignity. Thank you, sir. Thank you for joining us. And now I hand it over to our Senior Vice President, Mr. Pradeep Multani, for the formal welcome address for today's this special session with Honorable Justice.
Thank you very much, Dr. Ranjit Mehta. A very good evening to all. It is indeed a great pleasure to welcome everyone, our distinguished guests, eminent speakers, and delegates to this unique conference on virtual conference on arbitration norms for infrastructure sector. We are very grateful to Honorable Justice Mr. Deepak Misra, former Chief Justice of India, for accepting our invitation and gracing the occasion. Your Honor, we look forward to hearing your views and learning from your vast experience and knowledge. We also have with us today other eminent experts, Mr. Ashish Mohan Vig, Mentor, Infrastructure Development Committee, PhD, Mr. Sudhir Hoshing, Chair, PhD, Infrastructure Development Committee, Ms. Priya Hingorani, Senior Advocate, Supreme Court of India, and Chairperson, Law and Justice Committee, PhD, Mr. Alok Krishna Agarwal, Chairperson, Legal and ADR Cell, PhD Chambers, Ms. Kadambri Singh Puri, Advocate and Standing Counsel, NHAI, and Co-Chair, PhD Skill and Entrepreneurship Committee, members of Managing Committee, former presidents, Dr. Ranjit Mehta, Deputy Secretary General, PhD, distinguished speakers, colleagues from industry, friends from media, ladies and gentlemen. Arbitration in India is becoming a preferred dispute resolution mechanism in resolving disputes in infrastructure projects owing to the complexities of disputes involved. Over the last decade or so, a catena of court rulings, host of legislative acts, and amendments such as the Arbitration and Conciliation Amendment Act 2019 and New Delhi International Arbitration Center Act 2019, fast track arbitration, and establishment of specialized commercial courts have immensely helped in creating a very conducive atmosphere for execution and timely completion of especially infrastructure projects by ensuring efficient swift and effective dispute resolution mechanism, and enhanced India's image as a robust center for international and domestic arbitration. The challenges faced in arbitration of infrastructure project disputes include high stakes of the infrastructure project, involvement of multiple parties, calculation of the quantum of damages, review and analysis of a large volume of data at the time of the dispute, and requirement of technical experts. In addition, arbitration awards are routinely dragged with procedural delays challenged and taken up to the Supreme Court of India. These challenges make arbitration of infrastructure projects very demanding and would require a robust arbitration bar for development of institutional arbitration system in India, which would ensure availability and accessibility of practitioners with knowledge and experience in the field of arbitration. Infrastructure projects across the globe are faced with disputes. These disputes may arise due to a number of factors, such as delays in project implementation and the failure to comply with present project standards. Globally, it has been recognized that contract management and imbalanced contracts as the major causes of construction disputes in the past 5 years. In India, some of the best global practices can be followed, which have been successfully implemented across the globe, are the following. For example, under the new engineering contract 3 in the UK, a contractor has the right to suspend work either partially or fully in case of a delayed payment or handover of the site. However, in India, not a single contract model gives this right to the contractor. Enactment of a construction law providing guidelines on various aspects of construction projects, certain mandatory provisions to be included in the construction contracts and methodologies to deal with infirmities in bidding, contract evaluation, and payments is another crucial step which a few countries have taken. A construction law came into effect in China in 1991 and in the UK in 1996. Other countries such as Australia, New Zealand, and Canada have followed suit. Another initiative involved the adoption of an interim dispute resolution mechanism. In the US, dispute review boards have worked quite well, which was not the case with Canada and New Zealand. Therefore, these countries have a statutory adjudication process in place. Countries that do not have a construction law in place have introduced certain other associated laws which ensure timely payments and remove infirmities in contracts before their acceptance. For example, countries following the civil law system.
ठीक है
Rajit, silence please.
लिख दो उसमें no guarantee.
Rajit ji, please mute your. Please. For example, countries following the civil law system have specific codified provisions in place for dealing with construction contracts, such as a mandatory provision for price balancing in Kuwait. Infrastructure projects are dealt with various statutes, including the Indian Contract Act, Transfer of Property Act, various labor laws, etc. There is uncertainty in interpretation, which leads to disputes and protracted litigation. The contracts between the infrastructure companies and contractors are based on distorted versions of FIDIC, and there is no standardized format of the contract. Therefore, there is need to frame unified construction law for infrastructure projects for balanced contract conditions, timely payments, and speedy dispute resolution. Friends, today's conference objective is to analyze the recent trends and developments in arbitration rules and regulations with regard to infrastructure projects, discuss their impact, highlight the major issues and concerns, business opportunities, and discover the way forward. With these words, I once again welcome all the important conference on arbitration norms for infrastructure sector and wish all the success to the event. Thank you. Jai Hind.
Thank you, sir, for your welcome address. For the benefit, for the knowledge of Honorable Justice, I would like to tell you, sir, we started this webinar at around 3:30, which was addressed by legal luminaries like Ms. Priya Hingurani, Senior Advocate, Supreme Court of India, and Chair of PSD Law and Justice Committee, Mr. Alok Krishna Agrawal, advocate and also chair of PhD Chambers Legal and ADR cell that we are having. Also, we had Mr. Gautam Bhatikar, partner Phoenix Legal, Mr. HK Sharma, joint general manager legal L&T, Mr. Atul Nigam, partner Chamber of Nigam and Nigam, Dr. SB Saswat, managing director Global E-Auctions. So now we have a book which is the forward in this book is written by you. Thank you very much. And also the author is present here. I would request you, sir, to unveil this book for the benefit of all our audiences here, which I think the copy you must be having, sir.
Let me know.
So virtually, Dr. Saswat, the author of this book, is also there. So I'd request you, sir, to unveil this book in this conference. Thank you. Thank you. This is written by Dr. Saswat. Thank you very much, sir, for doing the honors. And thank you for releasing this book on construction, arbitration, delays, disputes, resolution. And the foreword of this book has been written by you, sir. Now, the people are eager to listen to you, sir, with your vast knowledge. Over to you, Honorable Justice Deepak Mishra ji.
Mr. Mehta, Mr. Multane, distinguished speakers. Actually, I agreed to participate in this webinar because I wanted to hear the experts. I did not intend to give an expert lecture. You see, there are two lawyers, I can see them, and they perfectly know, as a judge, when you deal with an arbitration matter, how much time you consume, what are the points raised, and how the High Court or Supreme Court deals with them. But when an arbitrator deals with it, the entire scenario is different. Very subtle and very nuanced aspects are projected with keenness. What Mr. Multani suggested, that in India, we must have some sort of specific law relating to infrastructure contracts. That's a matter I'm not going to touch. That's a suggestion, and he made number of comparisons with other countries. And one thing he told, that in other countries, at least 2 or 3, the contractor can drop the contract if it is not paid. The amount not paid within time. It's a running bill, as we know. They are developed countries. They have a different economic scenario. But here, I don't think that kind of privilege can be granted to the contractor. The psychology and the mindset has to change, and that will change with the flux of time and also with the battles that is fought during arbitration and the fights that take place in court. I think you must have debated, there has been prolongation with regard to arbitration proceedings. If the claimant tries to quicken it, to hasten it, the respondent makes all efforts to delay it. That is the psychology, and that is a psychographical substance in our mindset. After the mindset changes, I will be extremely pleased to work with Mr. Multani, because the proposition is a good one. The proposal is absolutely acceptable, that there should be even-handed balance, especially in an infrastructure contract. Now, when you think of arbitration, I would like to consider it's a human institution. It's meant for establishing a kind of economic balance which can be ushered in quite promptitude. When you file a civil suit, when there is no arbitration clause, all of you know, it takes quite a time. Some arbitrations may be taking time, but definitely not that much of time. And second, the scope of challenge in last 1 decade has decreased. The policy is minimum interference and maximum sustenance of the hour. Unless the hour, as you know, is really hit by the statutory provisions, the court is not going to touch it. The court is pro-arbitration. While I was putting myself on to join the webinar, 2 sentences were uttered by the author of the book, which we have released today. I think, as I gather, he was talking about the drafting of infrastructure contracts. Drafting is an art. Drafting a contract is a greater art. And drafting an infrastructure contract is an artful craft. I will give one example. A matter came before us 3 years back. The issue was whether the clause conveys 5 years or 7 years. The contract, the general conditions of contract, and all other annexures, quite a voluminous document at 4 places, use different kind of language. The High Court had interpreted that no, the period is 5 years and not 7 years. High Court was correct. We rejected the special leave petition. My comment at that point of time was, why can't you simply put that it is 5 years and not 7 years? Why do you put it in a very circuitous way 5 years here, 7 years there, to give rise to confusion. In these kind of contracts, whoever is drafting, there has to be a concept of mutuality to avoid ambiguity and bring in simplicity. Sometimes I was told after I demitted the office, sir, we are pressurized by the owner or the employer. For that, I don't have an answer. People like you really can convince or take leadership that don't do it. What is the law of the land? Draft the contract in that way, in absolute, unequivocal, unambiguous terms, because that really paves the path for good, prompt, and just arbitration. All of you know arbitration and the infrastructure field are inextricably connected. Infrastructure in India gives employment to 4 crores of people. That's quite a sizable population. They may be in the organized sector and they may be in the unorganized sector. But the splendid purpose is humanity is looked after and employment is taken care of. Article 21 of the Constitution, to get livelihood, is absurd in a different way. What I am trying to say, there are many state projects. There are many projects like railway, then airports, military, so many. They also give employment. My purpose of telling Article 21 was, it's not that it's a state's obligation to give livelihood. Livelihood can be generated where state has a stake. There are many state-owned corporations which are involved in this infrastructure activities, and they also employ, maybe not permanently, but project to project for years, at least 30 years, by establishing a structural pyramid for livelihood. That's one part. You see, in arbitration, especially in infrastructure arbitration, interpretation of the nature of the contract comes into play. Whether it's a lump sum turnkey contract or it is a different kind of contract, or it's a hybrid or mixed contract. I do not have to go to the nitty-gritties of law. A lump sum contract, I'll give a simple example. You want a house to be built. You give it to a builder. You say, I will say nothing. Everything you have to do. You have to look after everything. Don't call me. After the house is complete, you invite me to get in. That is absolutely a turnkey contract. Open the key and the owner gets in. Simply put. But when there are clauses that the employer will have say on at many a juncture, particularly the perception of the contract would change, which many analysts categorically say, then it becomes a mixed contract. In lump sum contracts, another question arises, especially with regard to infrastructure contracts. Whether in a lump sum contract, if a contractor has done extra works, he can be paid for it, or it is covered by the amount mentioned in the contract. Now the view is consistent. If there are extra works which can really be called extra works, please mark this repeated phrase. If they are nomenclatured as extra works by analysis, the contractor would be entitled to get the amount he has expended along with profit. Another aspect that crops up with regard to infrastructure contract, mostly during arbitration, is delay. Who is responsible for delay, whether it is the employer or the contractor? There is a beautiful saying in English. They say $1 million question. But there is an American. He used the phrase, it's a $64,000 million question. Only to give emphasis. Only to give emphasis. My purpose of uttering this phrase is to say that delay is quite a contesting concept in this infrastructure arbitration. And while judging delay, another kind of argument comes in big contracts, whether the delay has been caused by the employer in relation to and pertaining to critical path. That critical path, there has been many judgments of United Kingdom and the courts in Australia. In an English judgment, the learned judge gives an example, a very simple example. What is the critical path? He says you enter into a contract, you give it to X, and you say you have to carpet the entire building. That contract is given. Contract is only for putting the carpet. In the meantime, because of some embargo, the floor is not made. There is some hurdle that is given to the same contractor. He says, I can't put the carpet because the floor is not made and you are delaying. You are changing the design. Ultimately, the court says putting up the floor is a critical path for putting the carpet. If you are creating an impediment in the critical path, you are liable. Contractor is not. But the contractor has to show it is the owner who has created the obstruction or obstacle in a critical path. Be that as it may, Mr. Multani talked about, I personally feel he should have given more time. He could have addressed in a different way. He talked about damages. Damages in infrastructure contracts is quite a delicate thing to arbitrate or to judge. There are many types of damages, or damages crop up because of multiple factors, namely scope change. When I say scope change of design, change of map, many other aspects which go to the root of implementation of the contract. Second, obstacles, hurdles, or what you call disruption. Like supposing you have to build a hospital, certain land had to be acquired. There is disturbance, delay takes place. There's a disruption. And for that, who will pay the compensation? That has to be seen. Definitely, who was able to give the land? It is the owner. Whoever was responsible to get the land acquired and hand the site over to the contractor is responsible. But that delay also occurs due to infrastructure, occurs in this kind of contract. The other one is accelerated steps. Sometimes what happens, the contractor is moving at his speed. He is in tune with the contract, but the owners say accelerate the work. Acceleration of the work is dependent upon extra expenditure. You have to arrange the manpower, machine, and many other things. That acceleration adds and puts more costs on the building, on the infrastructure, and the contractor gets the liability. And there he has to claim damages. This may be very rare, but this is a component where the damages crop up as a factor in this infrastructural damages. Then, all of a sudden, as all of you know, for some reason or other, the contract is terminated. And once the contract is terminated, the arbitration springs up, and the claimant claims for damages by challenging that this termination is absolutely invalid and illegal. Whenever these damages come up for adjudication, be it arbitrator, be the court, looks at whether there is any kind of postulate or stipulation with regard to genuine pre-estimate of quantum in the contract. You see, look at the words used by the Supreme Court. It must be genuine and it must be pre-estimate. If that is reasonable, the court accepts it and pays it. If it is gets into the realm or sphere of penalty, the court searches for reasonableness, because there is a distinction, and quite a nuanced distinction, between penalty and genuine pre-estimate. Sometimes issue arises, who will prove the damages? The court has said, if the damages cannot be proved, because in every contract, in every sphere, it's not possible to establish. At that time, the courts of law followed the principle of reasonableness and grant damages. Now, in present time, in a society like ours, where we have global in economy, we have international arbitrations, we have domestic arbitrations, we have institutionalized arbitrations, we have ad hoc arbitrations, but we have to really propel the idea of arbitration, and the people, the institutions like you, who do webinars, seminars, workshops, and also involve people so that the process of arbitration can be facilitated. I must say, it's a great thing. Pandemic has not been able to make you static. It has not destroyed your marrows, your spirit, and your enthusiasm. In fact, that is what, and I must presently say, tempted me to participate today in this function, because I always feel and tell people, human mind can never be terrified. It has the spirit to fight, and all of you present here have the unvanquished spirit to fight. Thank you and congratulations. Thank you very much.
Thank you so much, sir. Thank you so much, Your Honor. And it has been a real privilege to have you with us. And thank you for agreeing to be a part of our webinar, sir. It was a very deeply insightful and spiritual, spirited address, sir. And Mr. Pradeep Multani, our Senior Vice President, would like to share some thoughts and questions with you. Over to you, sir. Thank you.
Thank you, Bhavna ji. Honorable Justice, sir, what a wonderful talk from you. So just one humble request to you. Sir, in today's also paper, there is an article that 40% of the vacancies on High Court are vacant. This is a statement by the Honorable present Chief Justice. We fail to understand why can't these basic vacancies be filled up? This is making achieving ease of doing business a complete disaster and a fiasco. Assuming somebody is coming to the retirement age, 6 months before that, we fill up that gap in our own organizations. What is the problem? Why? We have outstanding people like you in the judiciary. We have good government also. What is the problem? So we would humbly request that we need all the vacancies to be filled up, and also there should be doubling of the courts, because justice delayed is justice denied. So we strongly seek your help in achieving that. Thank you, sir.
No. You must appreciate that. I think the matter is sub judice. I think the Honorable Chief Justice of India has taken it up. You are right in a way. There should not be any vacancy in the high courts. But I think steps are being taken. Let's hope for the best and let's hope for the affirmative results. One, you said about increasing the strength in the high court. You see, they have increased, but our judge and population ratio is different. We really cannot compare it with UK and USA. We have to wait for some time because they are gradually increasing. You see, I will name one high court. When I joined there were 32 was the strength. When I left the high court, the strength is 52. I think there are 42 judges functioning or 44 judges functioning. I don't know exactly, but the strength is there. If they are filled up, I think your grievance will not be there as a citizen.
Thank you, Your Excellency. Thank you, Honor.
Thank you so much. May I take your permission, Your Honor? A few of our speakers would like to share a few thoughts. If that's okay with you, may I call upon Mr. H.K. Sarma, Joint General Manager, L&T IDPL, to please share his thoughts with you. We'll just take a few minutes more of yours, Your Honor. Thank you.
No, that's okay. That's fine.
Thank you. Mr. Sarma, you can unmute yourself and join.
Good evening, all.
Good evening.
Good evening.
Good evening.
Why doesn't put on? Let him put on his video. Okay.
We can hear you, sir.
Yeah. No. I just want that he should be seen. But the name is written twice. That's why I thought I looked at the bottom. Please ask him.
Yeah,
Sure.
my lords, it was a very interesting talk by you. You have given all the facets of the arbitration vis-a-vis the infrastructure sector, and you have touched upon all the requirements that we need to take care of during the drafting stage and all these things. It was a very interesting talk, my lords, and only one small issue that I would like to bring to your kind notice is in many of these matters in infrastructure, my lords, the awards are not getting honored, and most of the matters, it as a matter of routine, they have been filing appeals. So my lords, is there any suggestion from your side in respect of this?
No. Appeals are there challenging under Section 34.
34. Though it is narrowed down, but still they are filing, my lords.
You see, if it is a private sector, they are bound to file it because they want to see how long they can drag scope of challenge, and they can also pray to the court for lessening the rate of interest. Number one. Second, if it is a public sector undertaking, nobody can decide that amount shall be paid. They have to go to the court and the court has to decide. But as I told, there is minimum interference and maximum sustenance. And that you must have also noticed, depending upon the nature of the award and how it is written, unless they come within that small, narrow room of interference.
Yes, my lord. The judicial trend is almost now uniform, and the intervention, as you rightly observed, is now only in very limited grounds.
You see, I must tell you, because I don't know. You see, under 1940 Act, up to 90, there was no scope for interference at all. You may argue for 10 days before the arbitrator, adduce a lot of evidence. He may write one paragraph, so and so, so and so, so and so, and I think he's entitled to rupees 2 crores. I'm talking about 80s. And that nobody will interfere. You can read 1967 Supreme Court 1030, where the Supreme Court is referring to AIR 1923 Privy Council and says we cannot enter into the mind of the arbitrator. Then came whether the arbitrator should give reason or not. Then interest. Then eventually we have a real acceptably good law in 1996, further amended in 2015 and 2019. We are on the progressive path.
Well, it's very enriching, my lord. Your speech was very enriching to all of us, all the participants. Thank you so much.
Thank you.
Thank you, sir. Ms. Priya Hingorani, Advocate, Supreme Court. And
I know her, Priya. You want to ask what?
You want?
No, I just wanted to congratulate Your Lordship for such an enlightening talk and say it's such a pleasure to see you after so long. And we haven't been able to see you during the pandemic.
No, I'm not gone out, let me tell you.
No.
I have not stepped out of home.
Yes, that's why I'm saying, sir, we haven't been able to meet, but thank you very much for such an enlightening talk. And I just wanted to say one thing only, that at the PhD Chamber of Commerce, because Your Lordship and also other people have been saying that we must institutionalize arbitrations and mediations. So at the Chamber of Commerce, we took the initiative and set up the PhD Arbitration and Mediation Center, which was during my time when I was the chair of the ADR. But now Mr. Alok Kishan Agarwal is heading that cell and taking it forward. So we've had many arbitrations in the chamber itself, and under the leadership of Mr. Multani, who's going to now take over as the president in a few months, make it take it at an international level. And the unique thing about our cell is that we have our own rules. When we have requested our members to add the general clause in their agreements, and we have a mediation center which is doing very well, sir. We have pre-litigation mediations coming in from the industry, which is very heartening. I just wanted to bring it to your notice.
Who is mediating?
So we have mediators who are trained mediators from either the High Court Mediation Center or the Supreme Court Mediation Center under the MCPC, which your lordships have been guiding.
Yeah. Good. You see, actually, I must share with you, mediation can be really effective.
Yes.
Because it doesn't give, like Mr. Sharma said, Mr. Sama said, even if the award is challenged, though it's a good award, that's different. But in mediation, because it's a settlement.
Yes.
And in many of my speeches, I have conversed that in India, we must develop culture of settlement. You see, at least in a court, I have done many. In fact, party settled. I can share it now. I sat in a Sunday. You people may not be knowing it. There are big parties that I send them for that you discuss. After 3 weeks, the litigation they are fighting for 25 years, they say we are settled. And they filed the terms of settlement and it became an order of the court. It is the attitude. You see, private parties can settle. Anyway, good. Congratulations, ma'am. Good.
Thank you, sir. Thank you.
Acha, by the way, I just to inquire, have those workmen got the payment?
No, sir. We have had to file contempt, which is supposed to be listed soon, because that listing also is because due to pandemic is not taking place. They have not got a single penny. In fact, 25 people have died in the interim.
From 2014?
Yes. And they haven't got any payment. That's a sad state of affairs. Sir, I'll call you and I'll discuss with you. I'll call you.
No, no. No,
but
now
just
I am free. Now
Yeah,
I am free. I am free. Just I am able to ask you now. Otherwise, I wouldn't have
No,
asked.
sir. So, but we've had to file contempt, which is filed, and it's been taking so long in the registry to even get it listed. In fact, 3 people are suffering from cancer now. So
Okay.
Very.
Yes.
Yeah. Sorry.
Anyone else?
Sorry. Yes.
No, no, it's okay. It's a,
भावना जी, डॉक्टर एसबी सरस्वत साहब भी कुछ पूछना चाहेंगे, आई एम श्योर.
Sure, sir.
इतनी बढ़िया पुस्तक लिखी है, तो we must have the author coming in and getting his views also.
And His Lordship gave the foreword for the book, sir. So, Dr. Saraswat, would you like to address His Honor? So, you'll have to unmute yourself, please.
Good evening.
Good evening.
Justice Mishra Sahab. It has been my personal pride that you wrote 3 pages, and every word of the forward and review was a jewel. And I can never imagine that being so highly placed #1 citizen of this country could write so much on the book. In fact, sir, I'm so much motivated that I will be bringing out more and more books on arbitration, because I have seen the sides, both sides, one side as employer, other side as a contractor. And therefore, sir, I have tried to give A to Z in this book, right from conception of the theme of contracts, then looking for reasons of the disputes, which are purely technical, and I don't think anybody other than engineers can take care. And then, sir, I have portrayed the delay analysis, which is supposed to be a very logical conclusion for any arbitrator to be convinced. And finally, sir, I have touched upon the arbitration evidence, which is the basic need to justify that somebody's claim was right. And after all, everything is done. If claim is not justifiable, then the arbitration is not going to be conclusive. Sir, it is my personal pride, and I will be always delighted that I had so nice review. And I would like to thank you from core of the heart. And today, again, you have opened the book, which is very, very much in demand in the market, and a lot of people are calling me. And sir, I would like to once more thank you for that. And at the same time, sir, I like to give this opportunity in front of you that if anybody has got any question, any query, he can ask me right now in front of you, so that you will appreciate it. At the same time, they are requested to address it at any point of time. Subsequently, also my contacts are there. But sir, this is only the book on the construction arbitration in India. And in fact, sir, you have rightly told that the contract formation is the first thing which is required to address the disputes. And that is what I was talking to them before you joined, sir.
Okay.
Let us stop the delays.
I would suggest,
sir,
any author who writes a book, not on arbitration only, but on any subject,
sir,
he should cultivate to write the second book and thereafter the third book.
Sir.
There is a beautiful saying in English.
Sir.
If people wait for your second book, then you are a good author.
Well said, sir.
Mr. Multani, what do you say? I said, if people wait for your second book, then you are a good author.
Very right, Your Honor. And Your Honor, we are very privileged. We have got such outstanding senior advocate like Priya Hingorani, Mr. Saraswat and also Mr. Alok Agarwal. We have got a wonderful, powerful law committee here and the arbitration committee. And we look forward to playing our whatever little we can do to get speedy justice to whoever is needy.
No, I must say, I'm quite delighted that your mediation wing is functioning very well. And you can, when the pandemic gets over, you can think me as a mediator.
Wonderful, Your Excellency. It will be an honor come privilege, Your Excellency. Thank you, sir.
Sir, thank you very much, sir. Thank you very much, Multani sir.
Thank you so much, Your Excellency. Now may I request Mr. Alok Krishna Agarwal, who is the chairperson of the PhD Legal and ADR Cell, to share his thoughts and give the formal vote of thanks, sir. Over to you, sir.
Thank you, Bhavna ji. Justice Mishra, it has been a great privilege to hear you here, and it has enhanced the prestige of this conference to have you here. And we will take up on your offer, and we will request you to visit us at our premises at PhD once this pandemic is over. We'd like to take you around, show off to you the very good setup that we have here, sir. With saying so much, may I go ahead to give a vote of thanks to all the participants here, with your permission. Here I would like to thank all the distinguished guests, colleagues, the delegates who graced this conference and took the time and effort to be here with us. My special thanks would go to the speakers, the invitees, and all those who have ceaselessly and tirelessly been running around to bring about this conference. A big gratitude to the solid support and institutional systems made available by the leadership, the President, Mr. Sanjay Agarwal, the Senior Vice President, Mr. Pradeep Multani, who is here with us and who will shortly be the President, next President, and the Vice President, Mr. Saket Dalmia, the Secretariat and the Deputy Secretary General, Mr. Ranjit Mehta, who had been with us and had to suddenly leave for some important work, ably assisted by Bhavna Singh ji. For his insights and tireless pursuits, thanks will have to go to Shri Sudhir Hoshing, Chair, PhD Infrastructure Development Committee, and to Mr. Ashish Vig, member, for always being on the go and making the whole conference in a lighter and more informative manner. I would have a special mention to Ms. Priya Hingorani, Senior Advocate, Chair of Law and Justice, for always so graciously and profusely sharing her insightful experience and knowledge. I am grateful to Ms. Kadambari Singh Puri, who brings her domain expertise and insight into this conference. Mr. Arjun Chaudhary, who has very ably moderated the whole exercise with his exceptional way of limiting the time of everyone, as also getting everything out from each and every speaker. Also my thanks to Mr. Sharma, Mr. Gautam Bhatikar, and to Mr. Atul Nigam, who was very candid in the way his thoughts were about arbitration. Dr. S.B. Saraswat, for his book and for his so well participation, so much being into the conference, I have to thank. We had a very inclusive plenary session here, my lords, earlier, and the panelists gave their own views about everything, which we will like to present separately before you as and when you have some time. And we would also like to have you here at our PhD chamber premises whenever the time permits at your end. And with these, I would express my gratefulness and gratitude, especially to Justice Mishra, whose very presence enhanced the purpose, I would say, as also the stature of this conference. Gratitude, grateful.
Thank you.
Thank you so much, sir. And a big thanks to Phoenix Legal for supporting the program and for making it so. And again, a big thanks to you, Your Lordship. You just added, great value to our webinar, and we look forward to interacting with you in the future. Thank you so
We
much.
must have Justice Mishra over in the chamber once our physical starts to look at our mediation center and the arbitration center.
And I must say that this mediation center, my lord, has been brought about by Priya Hingorani ji. She has been the creator. She has laid down a very big template which we are actually following. In fact, she is the person who started it.
I know. After pandemic is over, I will definitely go.
Yes, sir. Thank you.
Yes.
Thank you, sir.
Your honor. It will be a
Thank you.
But pandemic will not be over when the pandemic is controlled.
Controlled. And the vaccine is taken. And the vaccine is taken.
Yes, yeah.
Thank you, Your Excellency.
Thank you.
Thank you, sir. Thank you, everybody.
Bye.
Thank you.